Welcome to this module on forest conservation. In this module, we will try to understand what are the major forest laws in India and what are their key features and how these forest laws in India has evolved and what are the major role played by the Indian judiciary in shaping the forest law regime. So before we go into the substantive details of forest laws in India, let's try to understand why we need to discuss about forest. There are mainly three uses of forest: one, ecological, economical and cultural. Ecological in the sense that forest is an essential part of the ecology, and that whether it is for facilitating rainfall, whether it is for maintaining quality of the soil, or whether let it be the case of providing habitat for wildlife. The economical aspect of forest is that forest provides raw materials forest is an adobe of rich resources. It provides raw materials for several industrial purposes. So in that way, forests are extremely significant for economical activities. The third part is forests are not just significant for ecological or economical reasons, but it has some cultural dimension too, especially when we look at forest from a tribal point of view or traditional forest dwellers point of view. For example, it is part and parcel of their life too. And as far as the degree of forest is concerned, I mean, ideally 1/3 of the total land area of the country should be under the forest cover. Now the question is, since we had already set a threshold called 1/3, what is the present scenario of forest cover in India? According to the Forest Survey of India, forest cover in India has been declining, and there are several reasons for it. Some of the major reasons are big development projects, mining activities, agriculture. For example, large part of forests are being removed for facilitating big development projects like big dams, and forests are being cleared for facilitating agriculture, or the diverse trees are being replaced by one kind of trees which are useful for industrial purposes. So there could be several other reasons, but the reality is forest cover in India has been declining. And it is in this context that we are discussing forest laws in India, as how this forest law regime contributes to mitigate these circumstances. And before going to the details, let us first have a mapping of what are the forest laws in its historical context. In India, we have long history of legal regulation of forest. So almost all standard textbooks or literature on forest laws in India goes back to the colonial period, where the colonial state introduced forest laws. So let's first look at the nature of those colonial laws, what kind of mechanism it envisaged to address issues relating to forest, whether it is for using forest or it is for protecting or conserving forest. Two important points in this regard is to understand about the colonial approach towards forest. The colonial government viewed forest as a source of raw material for several industries, mainly paper industries and railways. For example, they needed a lot of timber for construction for relating to railways, and forest was also drastically cleared for agriculture purposes. And different important forest laws includes Indian Forest Act 1865, Indian Forest Act 1878, Indian Forest Act 1927. Let's try to pinpoint some of the major features of this law, because these forest laws, these colonial forest laws, they introduced state control over forest. That means when they introduced state control over forest, the traditional forest communities were evicted from the forest. And these laws also facilitated exercise of monopoly over forest resources. It also facilitated monopoly over smelting industries. So altogether, the idea was to convert forests from public access to state control. And this also automatically resulted in the expulsion of traditional forest communities and tribals from forest, so that the state can exercise its monopoly. Now let us try to understand the major features of the Indian Forest Act 1927. Indian Forest Act 1927 introduced an interesting concept called reserved forest, the idea of reserved forest and the protected forest. This idea constitutes carving out of certain forest and notify it as reserved forest so that for better regulatory purposes. For example, it identifies and notifies certain forests as reserved forest. The moment it is notified as reserved forest, a number of legal regulation applies to that area. For example, prohibition of activities such as setting of fire, felling of trees, and even it also involves restriction on entry of people to that area. So to put in a different way, it involves removing or evicting all traditional communities residing in that forest so that that forest become under the exclusive control of the state. And the rationale for these actions or these concepts mentioned in the Indian Forest Act 1927 were conservation of trees, preservation and improvement of soil, protection of water sources. By looking at this rationale and the idea of reserved forest, it sounds like the Indian Forest Act 1927 was enacted for the purpose of protecting trees or protecting the forest habitat. However, there are several criticisms of these laws. By looking at the Indian Forest Act in a holistic manner, there are several loopholes or several criticisms, and it does not really confirm to the previous statement that whether this Indian Forest Act 1927 was actually for the protection or preservation of the forest habitat. Some of these major points are: actually Indian Forest Act 1927 sought to establish control and monopolize the use of forest. And the major idea was for the colonial state to earn income from the use of forest and forest produces. And this is quite evident from a number of other provisions in the Indian Forest Act. For example, look at the permit system as envisaged under the Indian Forest Act. The Indian Forest Act, even though they prohibits a number of activities, those are not absolute prohibitions. Many of these activities can be allowed provided the government permits it. That means essentially the Indian Forest Act 1927 introduces a permit system where many activities can be legalized with government permit and similar activities can be criminalized if it is without government permit. So the idea was just for a better monitoring and to earn or to enhance the colonial government's income from the use of Indian forest use of the forests in India. So there are several other provisions which also reflects the economic angle of Indian Forest Act. For example, it has detailed provisions on levying duty on timbers, and it also has a detailed provision. It entrusts power with the state government to prescribe the channel of transportation of timbers. It also controls the channel of transportation. The idea is, the idea seems to be like the purpose of the law was to make it easy for the government to monitor and monitor all activities in the forest, and also to make it easy for the government to collect revenue. So let us try to summarize this critique of Indian Forest Act 1927, because what we can see is that 1927 Act paved the way for commercialization of forest in India, because it enabled the colonial state to exercise exclusive control over the government. To put it in a different way, it enabled the government to evict or to dissociate the traditional forest communities from their natural habitat. And it also helped, or it also facilitated this approach of viewing forest as a source of revenue and raw materials, rather than viewing forest as an essential part of the ecology that needs to be conserved and protected. And the result was large scale deforestation and deterioration of the forest habitat, because the years following all these Indian Forest Act, particularly the Forest Act 1927, what we had witnessed was a drastic deterioration of the forest habitat. Indian forests were cleared or destroyed for various industrial and other economic purposes, let it be for paper industries or for railway construction or for plantation purposes. So that means this was the context in which the independent India enacted a new law or another law to complement the Indian Forest Act 1927, which was called Forest Conservation Act 1920. The purpose was to mitigate or control the rampant deforestation going on in the aftermath of 1927 Act. So the Forest Conservation Act 1980 is quite clear about its two objectives. The first one is to put more strict restriction on the use of forest land for non-forest purposes. And the second objective is to control of de-reservation of forests that have been reserved under the Indian Forest Act. Because the context of the second point needs to be understood. For example, the reason why the Indian Conservation Act 1980 focuses on control of de-reservation of forest, because many states in the aftermath of 1927, it was easy for the state to de-reserve forest if they needed it for various other purposes. So the Forest Conservation Act sought to control that activity from the part of the state governments. The major features of this Forest Conservation Act 1980 are the regulatory power. It witnessed a major shift of regulatory power from the state governments to the central government. That means it introduced the mandatory prior approval from the central government for use of forest for non-forest purposes. For example, this actually presumed that the power exercised by the state government in the regime of 1927 Act, they used it for using forest for several other purposes. It was in their discretion what kind of use can be put for foresters. So this this 1980 statute, it introduced this major power, or it shifted major power from the state government to the central government, so that for all activities to use forest for non-forest purposes required mandatory prior approval from the central government. So for two other purposes which also required prior approval from the central government are to de-reserve forest and also to lease out forest to private agencies. That means when we look at these provisions all together, the idea was to concentrate more regulatory powers on the central government, and so that major powers exercised by the state governments during the 1927 Act was taken away. Again, this presumption that the central government is more serious about protection of forests, this is questionable, and there is no reason why state governments are not serious and why the central governments are expected to be more serious, which is not quite clear. Maybe because different state governments were following different policies and different approaches. So the Indian Forest Act 1980 tried to consolidate the ecological part of protecting forests in India. And we also need to spend 1 minute on this concept of non-forest purposes. This is the key part of Indian Forest Act 1980, which mandates prior approval from the central government to use forest for non-forest purpose. The term non-forest purpose has been defined in the 1980 Act as, let me read it, breaking up or clearing of any forest land or portion thereof for the cultivation of tea, coffee, spices, rubber, palms, oil bearing plants, horticulture crops or medicinal plants. So the idea is, the concept is not to clear forest for cultivation purposes or for other economic purposes. And in this case, an exception is breaking up of trees for the purpose of reforestation does not come under the definition of non-forest purposes. That means the state government can introduce or take initiatives for reforestation purposes without the mandatory prior approval from the central government. Another major feature of the Indian Forest Act 1980 is the Forest Advisory Committee at the central level, because as I have already mentioned, this one of the key features of the Indian Forest Act is this prior approval, the procedure of prior approval. And in this case, this Forest Advisory Committee is the major institutional mechanism that facilitates the central government to grant or not to grant various requests or proposals for use of forest for non-forest purposes. In this case, the Forest Advisory Committee constituted at the central level, they advises the government on grant of approval, and they can also specify various conditions and restrictions in such permission for diversion. That means, this is a mechanism, this is the way that the Forest Conservation Act seeks to regulate the diversion of forest for non-forest purposes. Now the major third part of this module is the forest conservation and what kind of role the Indian judiciary has played in terms of shaping forest laws in India. To summarize this, I mean the major roles, I mean judiciary has been playing critical significant roles in terms of shaping or widening the scope of forest laws or shaping new rules. For example, let us take the example of how the judiciary has widened the scope of Indian forest laws. For example, first they widened the meaning of forest, and one important case in this context is the Godavarman case, where the Supreme Court defined forest as all land recorded as forest come under the purview of Act. And there is a specific context in which the Indian Supreme Court has widened this scope, because as per the earlier definition, various state governments were applying a very limited definition of forest to include only reserved forest under the definition of forest. The Supreme Court expanded the scope of this definition and included all forest in its dictionary sense, as well as all forest as notified in the government documents as forest under the Forest Conservation Act. The implication of this judgment is that now the state government's power is limited in terms of all forests, because the state government has to seek prior approval from the central government if they want to use all these forests for any non-forest purposes. And the Indian judiciary has also played significant roles in terms of regulation of various activities in the forest, and it could be in the case of permitting various activities, or it could be the case of prohibition of several activities. For example, let us take this Godavarman case again, where the court prohibited sawmills near forest, and they introduced this rule of 100 km, and all sawmills should be away from, beyond 100 km from the forest. That means all sawmills which are within the limit of 100 km from the forest, the state governments were asked to remove such sawmills. So that means the government, the Supreme Court was actually interpreting the forest law and introducing new regulatory tools or new rules under the scope of Indian Forest Act. And similarly, they also ordered for a complete ban on felling of trees in the tropical evergreen forest in Arunachal Pradesh, again in the Godavarman case. So this is to be noted that Godavarman case is an extremely important case in the context of forest laws in India. For example, the Supreme Court has taken this case as a continuing mandamus, and Supreme Court, under this case, Supreme Court continues to monitor various rules and regulations and implementation of forest laws in India. And it has widened the scope of this case, and now and introduced a number of rules, and this prohibition of sawmills or complete ban on felling of trees in the forest in Arunachal Pradesh. These are just some of the examples where the Supreme Court has introduced several rules under as part of this Godavarman case. Another important thing in this context of permission and prohibition is whether housing colonies can be allowed or permitted in the forest. But in this case, in the Goa Foundation case 1999, the Bombay High Court said, I quote, housing project after conversion of the natural reserved zones would be an eyesore in the green belt. The implication is that the court disapproved this idea of housing colonies, setting up of housing colonies in the forest, and they concluded that this amounts to an unacceptable use of Indian forest. And also they did not permit this setting up of housing colony in the interest of protection of forest. Another landmark case where the Indian judiciary contributed significantly, whether positively or negatively, is the Konkan Railway case 1992, where again the Bombay High Court, this Konkan Railway project was challenged before the court, citing that a number of trees had to be cut for facilitating this Konkan Railway project, and also because of the environmental implications this project was going to cause. But however, the court took a different view, and court justified the Konkan Railway project by highlighting the necessity of such a railway line. Let me quote an important paragraph from this Konkan Railway case 1992 is, I quote, the project of such magnitude of providing the rail line passing through more than 3 states cannot be held back by catering to the alleged grievance of the petitioners that the trees are indiscriminately cut. what we can see, a common element from this Konkan Railway case as well as from the previous Goa Foundation case on housing colony is that the court makes certain decisions, and the court steps into the bureaucratic role and or the court steps into the role of the executive and decides what all activities can be permitted or what are the activities not to be permitted in the forest as per the Forest Conservation Act. Because one common element in both these cases are the setting up of housing colonies or a development project to the degree of a Konkan Railway were justified on the ground that this is of national importance. Konkan Railway project was justified on the ground that this was for national importance, so little implications on forest could be considered as inevitable if we wanted to have this kind of project. Whereas in the case of housing colony, this was disapproved or this was not recognized by the judiciary, by the court, by the Indian judiciary as an activity to be permitted in the interest of public. And here another important point is the court is making or court is defining what is the public interest or what kind of project, irrespective of the fact that whether they cause implications or adverse implications on forest, what kind of activities can be permitted in the interest of public. While Konkan Railway project was identified as a project that should be permitted in the interest of public, housing colony projects were considered as not to be permitted in the interest of public, where the court gave more weightage to the ecological part of conserving forest, whereas in the case of Konkan Railway project the court gave more importance to the development project and considered the implications on the Western Ghat forest, the rainforest in Western Ghat, as inevitable to facilitate an essential development project. Similarly, in another case, which is Vanvasi Seva Ashram case decided by the Supreme Court in 1987, this is a case regarding approval of a National Thermal Power Corporation plant, and and the question was whether such a plant was to be permitted in the forest area. And again I quote first the major paragraph or major portion from this decision. I quote, "We cannot lose the sight of the fact that for industrial growth as also for provision of improved living facilities, there is a great demand in this country for energy. A scheme to generate electricity therefore is equally of national importance and cannot be deferred." So again I would like your attention again to compare it with the Konkan Railway case, and here again court is coming up, the Supreme Court has come up with a definition on what is public interest. So what are the major public development projects, or what are the development projects that can be justified in the interest of public even if it causes adverse implications or it causes injury to the critical ecological critical part, even if it causes adverse implications on forest habitats in the country. So here I would like to underline this important part, like the court specifically and explicitly mentioned that we need industrial growth and we need electricity and we need energy. So to facilitate some of these projects that can produce electricity or produce energy, so the court was of the opinion indirectly that we have to compromise some part of the ecological aspects of protecting forest. To put in a different way, in order to facilitate the economic development or in order to facilitate the project, like whether it is Konkan Railway or it is a project to produce electricity or energy, in such cases the court gave more weightage to developmental project than on than to the idea of what the purpose of conservation of project. So these are the few examples where we can see that that the provisions in the Forest Conservation Act, even though the act was primarily meant for the conservation of forest, these different definitions, so the scope of the statute has been defined differently according to the facts and circumstances of the case. For example, in one case where a housing colony was not accepted as an activity to be permitted in the forest, whereas Konkan Railway and an NTPC project for producing electricity, and these two projects were accepted and identified as a necessary project to be implemented, irrespective of the fact that it can cause adverse implications on the forest. Similarly, in the case of another major important thing or important changes introduced by the judiciary in the context of Indian Forest Act, Forest Conservation Act 1980 is Ambika Kori case 1987 decided by the Supreme Court. And the major issue in this case was whether a license issued before the act came into force, and if an industry wants to renew their license during the regime of the 1980 Act, whether prior approval is necessary in such context. For example, in this case the company had its license before Forest Conservation Act 1980 came into force, and the company wanted to renew its license once the act came into force. So in this case the question was whether the government, the state government needs to seek prior approval from the central government or not. In this case the Supreme Court specifically held that renewal of a license after the Forest Conservation Act came into being can be made only after getting prior approval from the central government. And here is the case. The Supreme Court said that in the case of Ambika mining industry, they had to, in that case the prior approval from the central government is mandatory, no matter whether license was issued before the act came into force. The renewal is considered. In this case what we can see is the court is again, it is unlike Konkan Railway case or the NTPC case. In this case the court is giving more importance to the protection of the forest habitat as well as the implementation of the purposes of Forest Conservation Act 1980 and making this prior approval system applicable to all those licenses or applicable to the instances of renewal of licenses or mining licenses issued before the act came into being. And another major contribution by the Indian judiciary is creation of ad hoc compensatory, which is called Ad Hoc Compensatory Afforestation Fund Management and Planning Authority. This is an important institutional mechanism introduced by the court. As per the Forest Conservation Act 1980, the central government was expected to constitute this body. However, even though a notification was issued, it never came into force, and this was the context in which the court introduced this idea of ad hoc organization, this ad hoc Compensatory Afforestation Fund Management and Planning Authority. The idea of this institutional mechanism is to manage the money received from the operation of act. Say for example, the money received as part of issuing licenses, and how this money can be used for better management of forest or for conservation and protection of forest. So now what can we see or what can we witness from this judicial the role played by the judiciary in terms of implementation of the Forest Conservation Act 1980. Even though the judiciary has widened the definition of the concept of forest, even though the judiciary has liberally interpreted the idea of non-forest purposes, there are several instances where the judiciary had taken different standards. For example, in the case of when they allowed some big projects, they refused to allow some small projects. And another major critique is that whether the Supreme Court, as it is doing in the case through the case of Godavarman case, whether the Supreme Court is able to micromanage forest administration. The capacity of the Supreme Court to micromanage forest administration is doubtful. And on top of that, even if the Supreme Court has the capacity to micromanage forest administration, is it proper according to the constitutional setup in India? For example, separation of, considering the idea of separation of power, whether it is proper for the Supreme Court to step into the role of executive, whether it is proper or whether we can justify it in the constitutional context. And again, what we can see is some of the rules or some of the decisions of the Supreme Court has actually triggered severe human rights violations. For example, the blind conservationism and the orders issued by the Supreme Court, on that basis it resulted in massive eviction of tribals and forest dependent communities, and that resulted in severe human rights violation. So the question is whether the Supreme Court actually had managed to balance on the one hand the conservation of forest, and on the other hand the the concerns and the rights of tribals and other traditional forest dwellers. So and all these points and all these concerns will be will be too critical in analyzing the role played by the Indian judiciary as well as the implementation of forest laws in India. So in summary, what we can see is that forest law has a long history in India, and at the same time it was primarily started by the colonial state, and the colonial state's interest was primarily how to earn income from the use of forests, and their major purpose, and that is the major purpose, the primary purpose of introducing Forest Act in 1865 and to consolidate in 1927 was to enable the colonial state to exercise exclusive control over the forest, so that they can monitor forest activities in the forest and collect or levy duties properly. Later on, this resulted in a drastic deterioration of forest habitat, and later on, and that prompted the enactment of the Forest Conservation Act 1980, and 1980 Act and 1927 Act together that constitute the major forest law regime in India. And on top of that, the Indian judiciary has played key role, whether positively or negatively, but they introduced key roles in shaping new roles or introducing new roles or widening the scope of Indian Forest Act, and also it is very important to highlight this point that the judiciary has been playing judiciary has assumed the role of executive in implementing the forest laws in India. Thank you.